Call a meeting to order. Mrs. Searles, do we have a quorum of at least 73 members? We do. 74, wonderful. We'll take up Article 23. Mr. Coram.
Yes, Mr. Moderator. I move that the town require the Select Board to annually report in writing on the town's progress towards accomplishing the goals set out in the duly adopted town plan.
Is there a second?
Second.
Motion has been made that the town require the Select Board to annually report in writing on the town's progress toward accomplishing the goals set out in the duly adopted town plan. Mr. Block.
Thank you, Mr. Moderator. Over the past 3 years, the Commission, in its research and interviews with town officials and department heads, and in listening to the public at large, found that there was often complaint, or at least observation, that our vision statement, which is the Brattleboro Town Plan, authored by hundreds of citizens, doesn't have teeth, or isn't able to be put into action, or doesn't have measurable goals in it. And though the Commission's work is not in any way involved with rewriting the town plan, which is happening this year, we felt it important to include some language and responsibility in our town charter that would help to raise up the town plan in the consciousness of the citizens and to give some meaning to the words in it that are measurable to the citizens. We have already seen a brief introduction to the preamble that recognizes a goal of the town charter is to work towards the vision of the town plan. But in our next article to consider, we recommend that annually, in a written report, our elected officials, our Select Board, report to us, the people, on how well we're doing towards meeting the goals duly set forth in our town plan. It doesn't tell them how to produce that report other than in writing, and no doubt that they would seek various different experts in town and outside town government to help contribute to that. But I think it would give a responsibility to people to keep the town plan alive and to allow citizens to follow how we are doing collectively as a community towards the very vision that we have helped craft.
Question is, shall you adopt Article 23? Mr. Gudemam?
Gary Gudemo, District 3. In my spare time, I'm the chair of the Planning Commission, and as Larry said, we're in the middle of rewriting the town plan right now, and so we have had several, well, a few hundred at least, people have input, and probably dozens of organizations and so forth. I'm going to speak against this, and you know, and it's not that I don't share the goal of having this be a living document. I really do. If there's anything that we have heard so far in the last 2-3 years about the town plan, is that people are concerned that it not gather dust on the shelf or be stuck in a drawer somewhere. And I would say that, you know, 95% of the copies of the town plan to date that's where they've wound up, and they don't get consulted a whole lot. I think the answer to that, though, is rather than, my sense of this kind of reporting would be to make the plan into sort of a set of ordinances in some ways. I know that may not be people's intent, but I think when you require a written report, it's going to either reflect poorly or well on somebody. And I don't think that's the point of the town plan. I think the burden that is placed on the Planning Commission and the Planning Department and the town generally, and the people in town, is to make the vision, well, to start with, to express the values of the people in town such that people can recognize their own values in that set of values. And to me, that's probably the number one most important thing. That's what makes it a living document. And then the vision flows from that, and then the action plans flow from that. The other part of this that's probably hard for me to get even is as much as we've talked about it, is that there's the big T town and the small T town. And the big T town is the town government, the staff, and so forth. The small T town is all of us, and as citizens. And so there's a lot of expressions of the vision and values and desires and aspirations of people in town, in the town plan. There are some action steps that are pegged to particular people and departments and so forth of town government and staff, but a lot of things are things that the community at large would like to have happen and feel a sense of responsibility for. I think the challenge really is to get the right stuff in there, number one, and you do that, I think, by having the right process. And then what I would offer as the alternative to this, because I think it is good to have follow-up, would be to have the Planning Commission be responsible for reporting to the Select Board annually on the provisions of the town plan, the action statements and goals. Because I think that's, the Planning Commission is the most intimately involved with, the point by point, what's in the plan. It's going to be the most familiar with it. And I think that would be a great thing to have. I think we plan on putting that into the implementation chapter of the plan. So that makes the most sense to me. I think the other way, I don't think it would achieve what we would hope. So.
Question is, shall you adopt Article 23? Are you ready for that question? Yes. Mr. Dudman.
We spent a lot of time, excuse me, around this issue. And as I'm listening to his comments, there's nothing that says that it isn't the planning board that should be writing this report. But then that report should go through the channel up to the select board. Until that gets to be a required exposure of what that plan is and what's happening, however it gets created, we didn't want to micromanage it and say so-and-so write it or so-and-so. But the responsibility is the overall group of people who are responsible for seeing what happens in the town. And that's the thrust of this article. And it may very well be, it depends upon the select board as they look at this, it may very well be that the planning board is the group that writes that report. but it goes to the select board and gets the approval and gets into. And if it turns out that there are some people, because they don't carry out their responsibility, and this is the remark that it might reflect badly on someone, then so be it, because one of the main thrusts we had was let's have some pathway for accountability. So I would say that everything he's talking about is fundamentally in support of what we're saying. Get it so that it has to be reported upon. It's not a whim anymore. It has to be reported upon.
Question is, shall you adopt Article 23? Are you ready for that question? Ms. Buboulis.
Well, just to add to what Richard said, the select board is the elected body. It's the executive branch. It's responsible for all of those things. It's responsible for what the planning commission does. And while the planning commission has certain legislative things that are put out by statute, the select board appoints the planning commission, and the select board can ask the planning commission to do certain things. I did actually make that suggestion, Gary, back when they were doing the informational meetings, and I was reminded of what I'm saying now, that while, you know, the planning commission is responsible for doing all those things, it's the select board that ultimately is making sure that all of those things are happening. And it is the public executive body that is elected, and it should go through the select board.
Question is, shall you adopt Article 23? Are you ready for that question? If so, all those in favor, kindly rise and remain standing. Those opposed, kindly rise and remain standing. The chair is of the opinion that the article passed unless someone would request a division. Hearing no request, the article does pass. Division. We'll take and have a division. Checkers, would you come forward here? All those in favor, kindly rise and remain standing until counted. Those opposed, kindly rise and remain standing until counted. Listen to the results of your vote. Those in favor, 43. Those opposed, 34. And the article is adopted. Article 24. Chair recognizes Mr. Coram.
Thank you, Mr. Moderator. Let's see. I move that the town approve the technical changes made to Article 4.
Is there a second? Second. Motion is made and seconded that the town approve the technical charges made to Article 24. We're on Article 4.
Mr. Moderator?
Mr. Block. Mr. DeGray.
Mr. Moderator, I would like you to rule on a technical change, whether it is warranted here or in Article 34. Back several articles ago, which may have been several months ago, I've been here so long, about changing the terms of the select board when they take office. And talking with counsel, he thought that you should make a ruling on this, and the technical change that I would like to make is that select board members not take office until the first Monday after town meeting, something I had talked about back when we were talking about select board terms and defending budgets and going to town meeting. After representative town meeting, excuse me.
And where would that be now in the, in your proposal of?
What's that?
Okay.
No.
Okay. Okay. The chair would state that it appears from some of the discussion at the two meetings we've had on this charter change, there has been some concern about failure to have overlapping terms, so that you have sometimes a new board that basically has no idea of how the old board got to where they got when they have our representative town meeting. And it seems to me that it might make some sense to have this amendment so that the old board would continue and the new board would not be seated until after the March representative town meeting. So based on that, I'm just going to say, unless there's objection, I'm going to permit Mr. DeGray to make this amendment. At this time, it may be somewhat technical, but I think it's a technical issue that we've spent a lot of time talking about. And it seems to me that we ought to either decide up or down whether or not we want to do it. Hearing no objection, Mr. DeGray, you may proceed.
Well, Mr. Moderator, we've had a lot of discussion about issues with new board members and whether they be school board members and not just select board members, because school board members are in the same light, and a lot of these things today have been reflective of the select board, but it has the same impact on the school board. I believe that someone in a one-year term actually goes to town meeting, sitting at town meeting, defending a budget they didn't put together, and then they're out of office not defending the budget that they did put together. So this is really a simplistic change, and I hope that you would support it. We still go forward with our election on the first Tuesday in March, but those elected officials, similar to what we have in the state legislature and in our federal government, they don't take office until a specific date. And so this would have board members who would be leaving the board, at least present at the town meeting, defending a budget, whether they voted for it or against, to speak for or against, whatever they choose to do. So I strongly urge you to support this small technical change. It's something that I've heard for years and years and years, and I think this is a simple solution to correct that problem. Thank you.
Now, maybe what we ought to do, Mr. DeGray, I don't know if you have language that you've written out, or just so I can direct the members. I assume we're talking about Article 4, Section 5 on page 8, and we're talking about Section 5 and then Section A.
Is that newly elected select board members not take office until the first Monday after representative town meeting. Annual town meeting, excuse me.
Newly elected select board members shall not take office until
Shall take office. Shall take
shall
office.
take office.
Shall take office.
Okay.
On the first Monday
On the-
after town, after
on the first
annual-
town, on the first Monday after
Annual-
representative town meeting.
Yes.
Okay. After the adjournment?
Yes, which would be the first Monday. Well, after the adjournment of town meeting.
Town
That's a
meeting.
good,
Okay,
that's a good point.
okay.
Thank you.
Friendly amendment by
Yes,
Mrs. Manning?
That's correct. Thank you.
Okay.
That doesn't go to Article 4.
It should go in the article about school board direction.
Okay.
right.
They say that there's an article about school board members. We should put it in that for the school board.
Yeah, we can do that under Article 34 for the school board
Okay.
members.
Okay. Mr. Beatty?
It occurs to me that a problem that could arise from this is that the new select board members, the newly voted in select board members, wouldn't have the benefit of being at town meeting and seeing what's going on. I'm wondering if, I don't know if it needs to be in the charter, but we could just have a tradition. We could suggest to the lame duck select board members that they go to the town meeting to represent the budget that they worked on, if they're not going to be in office. It seems to me that this can create as many problems as it solves, the way it's proposed.
Question is, shall you adopt the amendment as proposed by Mr. DeGray? Ms. Boboulas?
Thank you. For those taking bets, this is probably going to be one of the issues that Dick and I are going to agree on. I support this. I mean, I was just saying to someone earlier that this particular town meeting, that there was only going to be one sitting board member who actually voted for the budget at this town meeting, which may or may not be a good thing. But I do think that if you're going to have a budget presented by a select board, and it's the select board bringing the budget to this body, then that select board that brought that budget should be the one sitting there to either defend it or not defend it, because not everybody votes for the budget. The only question I have is, Bob, you were saying, you were saying something about is it in the charter, or is it the state statute that says that after town meeting that they take office after? I mean, I just remember you saying something about that the other day, and so there's nothing in the state statute that says that that can't happen?
First, with regard to the charter, in Article 4, Section 5, it has at the first meeting after their election, the election of the chair and vice chair. So that would need to be changed, which is what Mr. DeGray's amendment goes to. In the statutes, the language is forthwith after their election, which generally is the it's usually the next day, first Wednesday in March.
Mr. Barber?
Thank you, Ryan Barber, District 1. I understand Mr. DeGray's amendment, and it makes sense to me. However, I would like to suggest that the language be added after subparagraph A of Section 1 of Article 4, so that it would say, "The Select Board shall be elected at large by the voters of the town from among their member and shall take office on whatever the day is." And then that would leave Section 5A to deal with the board's own decision on who shall be the officers of the board.
Mr. DeGray, you would agree with that? Okay. We can treat it as a friendly amendment, and the amendment is that we move it from Section 5A up to Section 1A. Yes, Mr. Underhill.
Ben Underhill, District 2. Having only lived in Brattleboro in Vermont, I would assume this is basically how other towns do it. When they have town meeting day on the voting day, they're defending the budget before the new select board has even been elected. So even if somebody's stepping down out of his or her position, they're defending their budget that they worked on. It just makes sense, rather than having 3 or 4 people, 2 or 3 people up there who may not have a good grasp of the budget that's being presented. Thank you.
Question is, shall you adopt the recommendation of Mr. DeGray? Mr. Wheelock.
I have a question for Town Council. Marshall Wheelock, District 2. I have a question for Town Council. Do statutes, Vermont statutes, speak to the termination of the term of a select board member, i.e., do you serve for 1 year? Do you serve to a date specific? Do you serve till a replacement has been elected?
Mr. Fisher is interrogated.
I don't have that right in front of me, but I believe it is until the next election. So that brings up a good point, that if the elections are going to be done on the first Tuesday, that the terms would run through the annual representative town meeting following the election. At least that way it would be clear in our charter if this amendment goes through. Is that worthy of somebody making an amendment, or a friendly amendment?
Mr. Agave?
I'm not sure whether this will work or not, or whether it matters one way or the other all that much. The first thing that struck me is, what do we mean when we use that term, defending the budget? I mean, we throw that word out, and we all assume that we all know what we mean by that word. And I don't know that that's really true, so whether we're actually discussing the same thing here. To me, I think what we mean by the word is that we are simply asking a person to share information about why they did what they did. And exactly why they need to be kept in office to do that, I don't know. There is no reason that they can't simply come to the front of the room or be in the audience or on the side to answer questions. I might also add, as I think back, among all the many, many town meetings I have sat through, if we look at defending the budget as I describe it, as simply explaining why something is there, why it was done, I'd say about 99% of all the answers come from the town manager or the finance director anyway. It seems like, although the select board is responsible, all the questions are in fact answered by the town manager and the finance director. And since I'm not sure what other ramifications there may be to having this 3-week or 2.5-week lame duck period. I would just soon leave it the way it is.
Question is on the amendment as proposed by Mr. DeGray. Mr. Coram.
Thank you, Mr. Moderator. I would encourage the members to support this amendment. You know, we have a president that's elected in November, but doesn't take office till about 10 weeks later. You know, I'm a perfect example this year that I'm not running, as is Martha and Daryl. If none of us, and I'm not, but I don't know about Martha or Daryl, do not run for town meeting rep, then there's no requirement that we be here on the 20th or 21st, whatever it is, of March for town meeting. And, you know, we're talking about, at this point in time, a $14 million budget or thereabouts. That's a big ticket item in my mind. And there may be questions that come up at town meeting in March 2011 that Dick or Daryl, Dick or Dora, might not be able to answer. Probably, as Spoon aptly points out, probably Barb will be able to. But there may be things that I'm privy to or whatever in the 10 meetings, 12 meetings that we had to develop the $14 million budget that you folks might be able to gather from me as a board member that you're not going to have the access to. And it doesn't matter this year, but 2012 and going on, that won't happen unless we pass this. And it hasn't happened in the past. And I think back about, well, it ain't broke, don't fix it. You know, I think this is the way to improve the situation. And I think that Dick makes a good point that a person that runs for a one-year select person position, and that's it, never defends, supports, discusses whatever at town meeting the budget that they have been a part of developing. So I think it's a simple solution to what has just never made sense to me before even being on the select board, that we do it this way. And we're talking about an election this year, March 1st, so on the 22nd, 23 weeks later, those three new board members would then begin their terms. And Martha, Daryl, and I, if we had this in effect, would remain on the board. We're still going to be year members, 2-year members, 3-year members. It's not going to be any longer a membership, but we'll be discussing one of the big things that we do here is at town meeting is approve or not approve and change, discuss, et cetera, for hours on end, the budget. And that's a big ticket item. So I would hope that the membership will vote for this.
Mr. Dudman?
Just a point of clarification. Would you repeat the language that will go into Section A? It seems to me it would be very simple, something like, and shall take office on the first Monday after the final adjournment of the annual town meeting. Is that the correct language?
That is.
Representative town meeting.
Representative town meeting.
Representative town meeting.
That's right.
Is that the language?
That's the language.
So that it's clear what's being voted. Thank you.
Mr. Cox?
Doug Cox, District 1. I'd just like to ask the Charter Commission if this is an idea that you have spent time with, and what your vote was, if you have, and why or why not it wasn't in the recommendations that you proposed.
Yes, Mr. Block.
Actually, though we didn't recommend this particular pathway towards achieving having the seated select board be prepared to discuss or defend their budget, we did recommend it by moving election day to the first Tuesday in November. That was one of our talking points as to why the move would be an advantage, and so this does satisfy that particular concern that we had.
Question is on the amendment proposed by Mr. DeGray. Are you ready for that question? If so, Mr.
Chris,
Chapman.
Yeah. Well, I'm just speaking as a one-year candidate for select board, and I think the amendment makes eminent good sense.
Mr. Wheelock.
Probably. Marshall Wheelock, District 2. I'm still concerned that we may want to include language in this amendment that allows the person who takes office at the first Monday after we're finally well, we'll get through this yet. After we finally conclude our business each year, that they then would serve until their replacement. Somehow we've got to get across the wording, and I think that's what Ken is working on, but that's my concern, that we don't go against state statute and have overlapping terms for our select board.
Mr. Fisher.
Thank you, Mr. Moderator. Might I just suggest, as a friendly amendment, I can't make an amendment, but the newly elected select board members' terms shall take effect on the first Monday after the adjournment of the annual representative town meeting. If we insert that, then if you go from Article 4, Section 1A, you insert that, and then Section B talks about the one select board member being elected for a term of 3 years, others for 1 year. Then the terms, we'd be talking about the terms, and those would start from that right after annual representative town meeting.
That's what I said.
Miss Manning, you were up. Okay. Is there a second? No. Yeah. What we're gonna do is procedurally, we're gonna say that we're gonna withdraw Mr. DeGray's first motion of amendment, and we're gonna substitute this one that has just been read by Mr. Fisher.
Could we hear it again?
Yes, I'm going to ask him to read it again. Okay, Mr. Fisher.
That, of course, requires me to remember what I just said. That's harder than it seems. Newly elected select board members' terms, members S apostrophe, terms, shall take effect, or shall begin, on the first Monday after the adjournment of the annual representative town meeting.
Okay. So the question now is on the substitute amendment as proposed by Mr. DeGray. Mr. Beatty.
The question I have is, what if the representative town meeting takes more than a day? Does it just keep getting delayed until, if it gets delayed for 2 or 3 weeks, is the seating of the new select board delayed for that period of time?
Yes. Yes. Mr. Phillips.
Thank you, Steve Phillips, District 3. I think this all makes really good sense. So we're making sausage here, and this is a really messy way to get to a good result. My biggest concern, and I see a little bit of a pause in our attorney about the forthwith. So let me ask this question. Are we going to have a problem legally if we counter the state statute, or is it absolutely clear that when the legislature adopts whatever change we come up with, that we and they are trumping the state statute?
Mr. Fisher.
Thank you, Mr. Moderator. In my opinion, given that the charter will be not only a newer piece of legislation, but also more specific than the general state statute with regard to the seating of select board members, that the charter, if this amendment goes through, would take precedence over the state statute. Yes, the general state statute.
Question is on Mr. Mr. DeGray's substitute amendment. Yes, Mr. Dudman? You'd be recessed. Why don't we have a final adjournment of the, yes. Yeah, let's make it that. Yes. Are we ready for the question on the substitute amendment? Mr. Sprite.
Rick Sprite, District 3. A couple different things. We're on technical changes again, and we're dealing with substantial stuff, which I don't have a problem with. I'm glad we're doing this in order in this case. I like the idea of having the select board members who were involved in the process seated up there and available to be questioned. I also like the idea of having the incoming ones available, and not sure how to do this. They obviously can't be holding office at the same time, but I guess my preference would be to vote this down and encourage the outgoing select board members to show up anyway and be there and available to answer questions. But one way or another, whether we do it that way or we do it this way, I would like all of them there and prominently available, whether they have, whether they're impaneled or not. That would be my wish. I also have some other slight technical changes to this part, which I've been advised should wait till Article 34.
Ms. Johnson.
Ronnie Johnson, District 3. I would just like to say there's nothing preventing the newly elected town select board members to be here, and if they aren't town meeting members as well, be seated out there and interrogated by any of us at any time, I think.
Question is on the substitute amendment. Ms. Baboulas?
I just want to suggest that if the concern that people have is that the newly elected people, and I have to say that most people running for select board also run for town meeting rep, and a lot of them are already town meeting reps, so, you know, many of them are going to be here, but, you know, we already dealt with the issue of who's a town meeting member earlier in the other day, but that may be a way to address it, is to just say that those new members are town meeting members or ex officio members or something, so that you could, you know, so that you could deal with that. I don't think it's as big an issue, certainly, to not support something like this. I do think that there needs to be a way for them to be a part of the meeting.
Question is, shall you adopt the recommendation of the substitute amendment of Mr. DeGray? Mr. Webster? Motion's been made to cease debate. All those in favor of ceasing debate, kindly rise and remain standing. Those opposed, kindly rise and remain standing. The chair rules that there is a three-quarter majority in favor, and therefore, unless someone requests a division, the motion carries and debate is ceased. And the question is solely on the DeGray substitute of amendment. Are you ready for that question? If so, all in favor, kindly rise and remain standing until counted. Those opposed, kindly rise and remain standing. You've adopted the DeGray amendment. The recurring question is, shall you adopt Article 24? Mr. Phillips.
Thank you again, Mr. Moderator. Steve Phillips, District 3. So I have another amendment. This one is an amendment to a different section. And I suppose we're still on the global technical amendments that are all incorporated here. So this one is in Article Roman numeral 4, Section 5, Paragraph C. The Select Board shall appoint a town manager and may remove same for cause. My amendment is to delete the words "for cause" and to end the sentence at the word. Okay, am I out of order? I think this is 24. We're on order.
Yes.
And I think this is within that one.
Okay, so Mr. Phillips moves that in Section 5C, it will read, "The Select Board shall appoint a town manager and may remove the same, period, striking out "for cause." And then you want the rest of that sentence, that second sentence, to be deleted in its entirety?
No, the rest can remain. The only change would be to delete
"for cause." Okay. Is there a second? Okay.
If I may speak to that.
Yes, you may.
So many of you may remember that we had a legal dispute some time ago with a town manager that was very costly and protracted. And what many of you may not know or remember is that those words "for cause" were key words, which I believe were one of the reasons it cost us so much. So "for cause" sounds fairly innocent, and I think we can all agree that no one should be terminated for no good reason at all, but that's not what "for cause" means. "For cause" means that either the parties have to agree on the reason, or the employer, here the town, has to prove it beyond a preponderance of the evidence. So there are appellate rights that go with that, and we saw those played out on cable TV, if you remember, at length and at great expense. A lot of attorney time. So my feeling is that the town shouldn't be forced, in its charter at least, to explain or to justify the rationale for a termination. When the time has come, the time has come. If a capital crime is committed, if it's clear that embezzlement has occurred, there should be no argument. There should be no lingering. The right decision would be to terminate. And that doesn't mean that I think that the Select Board and the town manager can't contract differently. And maybe they decide that that's what they want to do. But I don't think it should be a charter provision that is absolutely required. And I'll give you one example. We may have a new town manager someday who comes in on an interim basis, or a temporary basis, or a trial basis. And does that mean that once they're in the door, you can't get them out? Because that's really legally what you will find "for cause" turns out to mean. You just can't get them out without a final resolution, which means all the way to the Supreme Court. Thank you.
Question is on the recommendation of Mr. Phillips. Are you ready for that question? Mr. Fisher.
Thank you, Mr. Moderator. My concerns legally with respect to Mr. Phillips' recommendation is that if you remove the two words "for cause," then we're left with a charter that says and may remove the same, and then you have state statute, the town manager statute, which requires removal to be for cause. And the question then is, which is the more specific statute? And that may not be, while I opined earlier that we would have a charter that was more specific and more recent, in this situation we might have a charter change that's more recent but be less specific, and general rules of construction are that specificity rules over generality. So I question whether this amendment would stand up if indeed there was a removal, sort of at will, and then a town manager challenges that for not complying with the state statute on the town manager form of government. The other thing that I would want to check, and I don't know the answer, is that when Brattleboro adopted the town manager form of government, there are certain things that go along with that, with the statute, and I just don't know exactly when that was and whether it adopted the for cause at that time. It's certainly in the charter now.
Question is on the recommendation of amendment made by Mr. Phillips. Are you ready for that question? Mr. Elwell.
Some will say I probably ought to recuse myself from saying anything on this issue, but I have to. We've heard a lot today about fairness and equity, and my position would be that the selectmen do their due diligence when they hire people. Now, if they don't, then obviously there could be a problem down the road. But a town manager is a professional person. Some of them are more professional than others, but nevertheless, I think that given the position and the rather fragile relationship that sometimes exists between the board and a manager, that the manager is entitled to some protection, and I think this is little enough in spite of concerns that exist if you have a manager who could be a scoundrel.
Question is, shall you adopt the amendment as recommended by Mr. Phillips? Mr. Sprite.
I'd like to offer what may hopefully be considered a friendly amendment, and that is instead insert the words "without need for cause." To address Bob Fisher's concerns, specificity without need for cause, rather than deleting the words.
Mr. Phillips, do you?
I'm not sure that really does it, so no.
Okay. Why don't we at least, I don't like to get involved with making an amendment to an amendment. I'd rather take up the first issue see what happens to Mr. Phillips's amendment, and then we can go from there. Are you ready for the question, which is to adopt or not adopt the amendment made by Mr. Phillips to strike the words "for cause"? Are you ready for that question? If so, all those in favor, kindly rise and remain standing until counted. Those opposed to the amendment, kindly rise and remain standing until counted. The amendment has been defeated. Now, Mr. Sprite, do you want to, under the circumstances? Okay, so Mr. Sprite withdraws his amendment, which is without need for cause. So we're back to the recurring question, which is, do you wish to adopt Article 24? Mr. Penniman.
I may have lost a place since it's been some time since their last meeting, but I think Article 4, Section 1, Paragraph B has language that reflected two initiatives that were defeated, and they may, as technical changes, not be valid anymore.
Yeah.
So it's automatic.
I think what happens, anything that was changed by us in our vote will automatically be changed under the technical amendments. Is that correct, Mr. Fisher? Mr. Fisher? Yeah.
Thank you. That's correct. We would correct that, given that those other ones were defeated. These terms would reflect what is currently the case as far as the terms.
So we are now at Article 25. Chair recognizes Mrs. O'Connor. We're, oh, okay. The question now is, shall you adopt Article 24? Are you ready for that question? Okay.
I'd like to propose that we amend this to just the technical things, which is to say the capitalizations in there. And there are several substantial things that, if we're not going to take it up here, that I think we should look at under Article 34.
I don't quite understand your amendment. I think you got to be more specific.
There are a number of things in here, like the dates, that whole section at the end that we were just starting to talk about, that seem more than technical. So I'm proposing an amendment to just make the capitalization changes, which are the only technical ones that I see that are strictly technical, and strike the rest of the additional language.
It would be the chair's ruling. We're either going to vote it up or down. If you vote it up, you can amend it again under Article 34. But we're going to vote and not have people not understand what a capital change is versus a technical change.
I'm talking about the capitalizations of select
Mr.
board.
Sprite,
Okay.
you've got to be specific. Sit down and write something for me and bring it up here.
I
We're in
urge
recess
people
for 5 minutes.
I'm just going to urge that people vote this one down then.
All right, everybody stay in order. I want to move this meeting along. All those in favor of adopting Article 24 signify by standing to be counted. As amended. Those opposed? Resoundingly adopted. Article 25. Shall the town, Mrs. O'Connor.
Mr. Moderator, if you're in good humor, I would move that the town... that the town authorize the town manager to appoint a town clerk.
Is there a second? It's been moved and seconded that the town authorize the town manager to appoint a town clerk. Mr. Block.
To discuss this article, I would like to ask Mr. Agave to address the question.
Mr. Agave, may proceed.
This issue, question 25, to shift the status of the town clerk from a position that is ratified by the town meeting to a position that will be the same as a department manager under the town manager. And the issues were, that in that way it will clarify many of the murky issues about accountability and perhaps, if ever necessary, disciplinary actions and other such things, and sort of bring the town clerk's office into the fold of the administration. It was never clear what, or hasn't been to me personally, I don't think we did, when the town meeting was ratifying the town clerk, there seemed to be that was imbuing the office with a certain level of independence. And but we never really discussed that at length, whether it was necessary. The town clerk's position, in any case, was that most of what that office has to do is mandated by state law and not really controlled by the town manager. But who is it that will make sure that the town clerk is doing their job, and who would respond if there was a sense that it was not happening? And I will pass this on to Town Clerk Annette Cappy if you'd like to make any further comments.
Question is, shall you adopt Article 25? Mr. Cummings.
Chuck Cummings, District 1. I see this as just one more move to take away any authority that this board, this group of representatives might have. I see nothing wrong with having to ratify an appointment. I think we should defeat this and keep some of the authority here in the representative form.
Question is, shall you adopt Article 25? Mr. Wheelock.
Marshall Wheelock, District 2. I would urge people to vote against this motion. My feelings are that the town clerk has authority over our most sacrosanct public ritual, that of casting our votes. And I think that in an attempt to increase the democracy in the town, I think that her final reporting authority should be the town members as represented, the town citizens as represented through first the select board and then through this body, two elected groups. And this is nothing to do with the people currently holding either office, but the town manager is an appointed position, and I think that I, for one, would feel better if our polling places and voting practices were controlled by somebody who was responsible to the public.
Question is, shall you adopt Article 25? Mr. Phelan.
Peter Fallion, District 3. I think in all of these situations where we're talking about people that we know, it's very important that we distinguish between the position and the person, and that we're only talking now about the position. Is it a good idea to have this position appointed by the town manager, as it's being suggested? Or, as it's also being suggested, is it better that we have the system as it's gone along so far, which is that position is recommended to us as representatives of the people? That's where I think it should stay. So I would urge you to vote against this amendment.
Question is, shall you adopt Article 25? Are you ready for that question? Mr. Dimes.
There are a number of reasons. There are a lot of little reasons to vote against this or for this, but I think it doesn't seem right for an appointed person in an appointed position to have the power of appointing another person. But secondly, more compelling to me is I think we all enjoy, especially voting for Ms. Cappy on a yearly basis. It's one of the things we do with greater unanimity.
Question is, shall you adopt Article 25? Mr. Elwell.
I can recall on 2 occasions that we had a difficulty with the town clerk, and it fell upon me to terminate the 2 people that were involved. Now, this wasn't done by the representative town body. It wasn't done by the selectmen. It was done at the selectmen's understanding and agreement. But it was the manager who had to make the decision as to what was the resolution of the problem. I think that if you're going to hold the manager responsible for these kinds of issues, then you have to give the manager the responsibility and the authority to do it. And that's what this amendment would do. I know that you feel strongly that there could be intimidation on the part of the manager toward the town clerk in the matter of elections. But I think that's pretty small-minded, in my opinion, to look at the issue in that way. So I hope that you would approve this.
Question is, shall you adopt Article 25? Are you ready for that question? Ms. Sundag.
I would just like to point out that the language says the duties of the town clerk shall include all the duties prescribed by law governing all towns and cities in Vermont. So when it goes to the actual duties of the town clerk with regard to the elections, et cetera, and how things are maintained, that continues to go back to the statutes. And so I think that there has been some safeguard with regard to response to Mr. Wheelock's concern about mingling of the town manager into the elections. The elections are governed by the statutes.
Question is, shall you adopt Article 25? Are you ready for that question? If so, all those in favor, kindly rise and remain standing until counted. Those opposed, kindly rise and remain standing until counted. The nays appear to have it. The nays do have it, and you've defeated Article 25. Article 26, to see Mr.
Thank you, Mr. Moderator.
I move that the town authorize the town manager to appoint a town treasurer.
Is there a second? Motion is made and seconded to authorize the town manager to appoint the town treasurer. Mr. Block.
Again, turn this over to Mr. Agave.
Mr. Agave is interrogated.
Again, this issue is much like the preceding issue. It is a question of whether the office would be more effective if it was within the administration of the town and under the direct supervision of the town manager, and again is as opposed to what extent does the power or the way that the town meeting ratifies imbue a certain amount of independence, so our town treasurer and town finance office have a little bit of checks and balances in there, although it isn't clear how much of that really is and how much ought to be. So once again, it's a matter of who oversees accountability.
Question is, shall you adopt Article 26? Are you ready for that question? If so, all those in favor kindly rise and remain standing until counted. Those opposed kindly rise and remain standing until counted. Chair is of the opinion that the nays have it, and a division's been requested. All those in favor kindly rise and remain standing until counted. Those opposed, kindly rise and remain standing until counted. Listen to the result of your vote. Those in favor, 37. Those opposed, 37. The moderator votes no, 38, so the motion is defeated. Article 27. Shall the town approve the technical changes made to Article 5? Ms. Buboulas.
I move that the town approve the technical changes made to Article 5.
Motion has been made and seconded that the town approve the technical changes made to Article 5. Mr. Block.
Just a reminder that the technical changes are separate from what it is that we just recently discussed regarding the town manager, the town treasurer and the town clerk, leaving not much else here. But I do want to just note that one of the technical changes that's a little bit invisible in this article is the article itself. Heretofore, there was no article for the position of town manager in the Brattleboro Town Charter. The town manager responsibilities and description therein was found in the Select Board powers and responsibilities article. But to be consistent with most other Brattleboro charters that we reviewed, the town manager in towns that have such a system of government generally has his or her own article in the town charters, and we thought that that would be a distinct position deserving of such an article herein. But as you'll note, there are no other substantial changes, just the few capitalizations and the word representative in here as far as technical changes go.
Question is on Article 27. Are you ready for that question? Mr. Underhill.
I have a question, Mr. Moderator. J, where it says to control and supervise, to be the appointing authority for all town departments. Does that need to be adjusted since that person would not be appointing two town departments?
Mr. Fisher is interrogated.
Thank you, Mr. Moderator. With respect to that, the town manager still would be the appointing authority for those departments. For instance, people who work in the town clerk's office or in the treasurer's office, but not with respect to the actual town clerk or the town treasurer, which would be appointments by the select board ratified by town meeting. So those two sections would stay as are in Article
Currently Article 4.
Article 2. They would, I think they'd stay in Article 2, which is the ratifications of the appointments of town clerk and town treasurer. Those whole sections, I think, given the votes on the last two articles, would remain.
Question is, shall you adopt Article 27? Mr. Cummings.
Chuck Cummings, District 1. May I inquire of the town attorney?
You may.
Thank you. Is there not a statutory requirement that the town clerk have the authority to appoint their assistant town clerk? I have, as you know, not been familiar with the statutory requirements for some time, but that's my recollection as town attorney for many years, that it was the town clerk who appointed his or her assistant and therefore her successor if she was not there. And you said that the town manager would appoint those working in the office, and I just inquire as to whether or not that is accurate.
The one thing I'll need to check, you are correct. However, in most towns, the town clerk is elected. But I'll check that statute. It won't change what the language is here, and I don't know. Okay, so those folks in the town clerk's and town treasurer's office are appointed by the town clerk and town treasurer. So I stand corrected on that. That's part of the overall issues with regard to, and we dealt with this also with the library one, as to who appoints and who terminates.
Then in your opinion, who appoints the assistant town treasurer and the assistant town clerk? Is it the town manager, or is it the town clerk and the town treasurer, respectively?
If you give me a couple minutes, I'll check that.
Oh, I don't
So
want to take any. I don't want to take any more time. We've already
Well,
spent enough.
If you, I just don't want to guess. I can check that. I don't know if you want to,
Let me withdraw the inquiry. We'll let it stand.
Okay. Question now is, shall you adopt Article 27? Mr. Wilmerding, please.
I just have to make a plea for order here. Maybe I'm wrong, but I'm seeing substantive matters come forward under the rubric of discussing technical changes. And these substantive matters and even new motions have not been warned, and the public has no advance notice that these changes were going to be made.
Well, I beg to differ with you, Mr. Wilmerding. All of the articles that we have before us were available to all of the members, were available to the public at the town clerk's office, had been published in the newspaper. I don't know what more needed to be done. But I'm just the moderator. I don't, thank God, have to do anything in organizing this group, but I think, and we had many public hearings with the Charter Committee, and we had 3 meetings with the Charter Committee, which the public was invited to, and all of this was explained by their advisor, Miss Carrie Seacrest. Did an excellent job. So I just want to make sure you understand all these things happened. Mr. Fisher.
thank you, Mr. Moderator. I told you if you give me a couple minutes, and that little diversion was great for me. In reference to Mr. Cummings' question, that's actually in our existing charter with regard to the appointment of assistants, and it's in, what did I say, Article 2, Section 4, the ratification section. And for the town clerk one, it says that the town clerk has the right to appoint, subject to the approval of the select board, 1 or more assistants. And then it's the same language with regard to the treasurer. So that's actually different from state statute as well. So that language, given the prior vote, would remain. Clear as mud.
Question is, Mr. Cummings. Question is, shall you adopt Article 27? Are you ready for that question? If so, all those in favor kindly rise and remain standing until counted. Those opposed, kindly rise and remain standing until counted. The article has been adopted. Article 28. Shall the town, Mr. Coram.
I move that the town approve amendments to the manner in which vacancies on the school board are filled.
Is there a second? Motion is made and seconded that the town approve amendments to the manner, approve amendments in the manner in which the vacancies on the town school board are filled. Mr. Block.
Thank you, Mr. Moderator. To address this question, I would like to ask Ms. Johnson to speak.
Ms. Johnson.
If she's willing.
Johnson, District 3. I can't address the whole mile-long thing of red type there on page 14 of your annotated edition, except for the main substantive issue, which is that vacancies on the school board would well, before they had been filled by the select board, and the change is that they would be filled by the school board until the next election came up. So if there was a vacancy in April after the March vote, then that vacancy would be filled by the school board, and that person would be in office until the next March election. The rest of these things here are very technical. I can't speak to them, but we did have this language written in conjunction with the school board. So if there's anyone here from the school board who would like to speak to that, I invite them now.
Ms. Atkins? Atkinson?
Hi, Margaret Atkinson, District 2. This proposal change was brought to the commission early on, and it was just kind of sort of a matter of symmetry, which occasionally the school directors come up in this discussion in these symmetrical things. And one of it was that, you know, the current practice is if there's an opening on the school board, the position is advertised and then filled by the select board. Given that we are a separate body with a separate function and a separate budget responsibility, we thought that it would be symmetrical if our body was also able to fill openings as they became available, or alternatively, maybe then we should be the ones who fill openings on the select board when they come up in the middle of the term. So either one of those things would be okay with us, but because we understand the duties of the select board, we think, or the school board, sorry guys, we think that we'll just, you know, suggest that we stick to our own purview. So I would ask this body to adopt this amendment. If there are more than 3 openings, a special election is held. That's the subsequent paragraphs if you haven't read them. Thanks.
Question is, shall you adopt Article 28? Are you ready for that question? If so, all those in favor kindly rise and remain standing until counted. Those opposed, kindly rise and remain standing until counted. The ayes appear to have it. The ayes do have it, and you've adopted the resolution. 29, Chair recognizes Mr. Coram.
Mr. Moderator, I move that the town approve the technical changes to Article 6.
Is there a second? Mr. Coram moves, and it's been seconded that the town meeting representatives approve the technical changes to Article 6. Mr. Block.
There is under J, some new language that is added that fell under the technical umbrella here. And it has to do with contracting with a certified public accountant licensed in Vermont to perform an annual financial audit report on the condition of all school funds as required by Vermont statutes. I don't think this differs from existing practices, but to be more current with the charter, we work with town attorney to bring this language more up to date. Other than that, there aren't any other mentionable technical changes in this particular article.
Question is, shall you adopt Article 29? Are you ready for that question? Mr. Phelan.
Peter Fallion, District 3. It's a very small point, but in order to make the document consistent and remain gender neutral, I would ask that we include the word her under Section 3, A, under Prohibitions A. The last sentence, it says, no former school director shall hold any appointed office for which compensation is paid until 1 year after the expiration of his term of office. I would just add, or her.
Is there any objection by anyone to that proposal as a friendly amendment? Hearing none, so ordered. Question is, shall you adopt Article 29 as amended? Mr. Penniman?
I'd just like to ask the significance of the deletion of Section 5, Paragraph O, exercise of general powers given to the Select Board. What's the significance of that?
Member of the Select Board's interrogated or a member of the Charter Commission interrogated?
Mr. Moderator, I think I can answer that. If you look at the Section 6, it gives these powers in addition to the duties assigned by law, which is Section 563 of Title 16. In there, it defines the school boards as having the general powers of the Select Board with regard to the issues that are under the school board's jurisdiction. So that was deemed to be essentially redundant to have it outlined in subsection O.
Question is, shall you adopt Article 29, Mr. Wheelock?
I'll take the tall people's mic. Was any thought given to removing subsection P, when so authorized by the town school district meeting, employ a public accountant to audit the financial affairs of the school district and prepare the annual financial report? The wording is slightly different, but it sounds like it covers the same material that was in J, with the exception that instead J says they have to, and P says they should if they're told to by the annual school board meeting, school meeting. P. And your annotated copy, page 14, last paragraph.
Ms. Johnson, were you able to find? Okay. Mr. Wheelock, did you want some, you made an inquiry, or was that just a statement?
It was an inquiry.
Okay.
With an addended statement.
Okay. Yes. Mr. Dudman?
There is a slight difference in the two. One of them says that there will be a yearly one, but presume or assume that you get the condition where something seems to be out of whack. Then the other one gives you the ability, in fact, to then have another audit done. So one calls for an annual one. The other one is there which provides the circumstance that somehow things get out of whack.
Question is, shall you adopt Article 29? Are you ready for that question? Mr. Sprite?
Perhaps the problem with that last section is the word annual. If we eliminated the word annual from that, I think it would serve the purpose that you had in mind.
Not necessarily, because then you might not do an annual.
No, that's required by J.
J mentions the annual one being required.
All right.
So what I'm suggesting is that if we eliminate the word annual from there, and there may be some other language that would...
Sometimes redundancy is terrific.
It's not, no, but it's not, no, it isn't.
No, what I'm suggesting is having prepare a financial report might be the way to put it in there, which would make it open to an additional one besides the annual one, which I think is what you were trying to say.
And I'm suggesting that redundancy is just marvelous.
I don't think you understand what I'm saying, but whatever.
That's my weakness.
Now, Mr. Sprite, are you proposing an amendment? No, I guess you aren't. Okay. Mr. Coram?
Yeah, I propose that we amend section 5P to delete the words at the end, the last phrase, the words, and prepare the annual financial report. So it would read, when so authorized by the town school district meeting, employ a public accountant to audit the financial affairs of the school district, period.
Motion has been made and seconded that in 5P, we strike out the words and prepare the annual financial report. Are you ready for that question? Mr. Truen?
This is a special circumstance.
Mark Truhan, District 3, and Brattleboro Town School Board. I would like to vote down, Mr. Moderator, the amendment that was proposed, in that one is in the annual financial report, and the other is the annual financial audit report. There is a significant difference. There has been some discussion that maybe in years coming, given the growth of the school system, that an auditor may be hired for the school district, which would allow that individual then to prepare the annual financial report.
Question is, shall you amend Article 29 as proposed by Mr. Coram? Are you ready? Or Mr. Coram, are you ready for that question? Does everybody understand the proposal of amendment, which is to strike in P the words "and prepare the annual financial report"? All those in favor of the amendment as proposed, kindly rise. Those opposed, kindly rise. As they say, that's too close to call. We're going to have the checkers do the count. So all in favor of the quorum amendment, kindly rise and remain standing until counted. Those opposed, kindly rise and remain standing until counted. Listen to the result of your vote. Those in favor of the proposal of Amendment 43, those opposed 32. The amendment is adopted. The recurring question is, shall you adopt Article 29 as amended? Are you ready for that question? If so, all those in favor kindly rise and remain standing until counted. Those opposed, kindly rise and remain standing until counted. You have adopted Article 29 as amended. We go to Article 30. Shall the town approve? Mrs. O'Connor. Excuse me.
Mr. Moderator,
Moderator, I move that the town approve the establishment of a Department of Assessment.
Is there a second? It's been moved that the town approve the establishment of a Department of Assessment. Mr. Block.
I'd like to recognize Mr. Dudman to lead the discussion on this.
Mr. Dudman.
Thank you, Mr. Moderator. This recommendation, along with several others, was centered around two of our strongest issues. One was producing the most effective form of government, A, and B, having some way to hold it accountable. The whole issue of taxes and assessment is a very, very intricate issue today. And as it presently happens, the people who do the assessment are elected as listers. They may have no qualifications, it does not matter. Whatever they do, that becomes the framework in which you end up being assessed for what you have to pay. They also end up being the first level of appeals. So in some sense, you have no way to get around them except then going to a higher level. So this was set up to establish a professional assessment which requires that the person who is in charge of the department be a qualified assessor, and B, that the work of that individual is then accountable through the town manager. The one person we're holding accountable through all of this is the town manager, and we have to give them the correct authority. Then the issue became, well, suppose one now disagrees with the assessment. So we kept the listers, but we shifted the listers who are elected by the population at large as the review board, so that the assessors then do not then judge what you bring as a complaint to them. Rather, you have your own fellow members. So we set it up as an official, professional department accountable to the town manager. It's part of your fundamental management team accomplishing what you want to see accomplished in the way of services. And we set up the listers as the first board of appeals. So if you disagree with an assessment, you now go to the listers whom you have elected as the ones to sit in judgment as to whether or not that assessment makes sense. So the whole thing is around the two fundamental issues of having an effective form of government, A, and somebody that's accountable, somebody you can go to and say, wait a minute, assessment in this town is way out of whack. Where do you go?
Question is, shall you adopt Article 30? Mr. Burrill.
Mr. Moderator, Leo Burrell from District 2. I have a amendment to propose. Basically, this amendment follows along and corresponds to each of the paragraphs as proposed by the Commission, with the exception that paragraph F has been added. There are two fundamental objections that I have to the proposal from the Commission. The first is, and I'm not sure that anyone, some people that are, if you looked at the history of the way reappraisals have been initiated in Brattleboro since the inception date of representative town meeting, you will see that the time when the era of illegal reappraisals started was when Mr. Fisher, all due respect to him, took over as town attorney. Prior to that, starting with in 1960 to approximately the year 2000, or slightly before Mr. Fisher's term as town attorney, there's a very clear pattern that has evolved. We had 3 prior reappraisals in that first 40 years. The first one was the Clemenshaw appraisal in 1976, and that reappraisal was commenced by a special article being placed on our agenda for this meeting, and that article contained the words of authorizing a reappraisal, and it also specified an appropriated amount for covering that expense. That article was adopted in 1974, 2 years before the actual completion of the reappraisal. And it was that article that initiated the project. In the next time we had a reappraisal, which was under the old 10-year rule for reappraisals, occurred in 1986. And the approach to that was a little different, but it was rather clear when, during the period from 1982 through 1985, each of those years that we met, an allocation of $40,000 a year was set aside in a reserve fund, such that by 1985 we had accumulated in that reserve fund approximately $160,000, and the following year the reappraisal project was undertaken and completed. In the 1994 reappraisal, that was actually commenced by a motion of a member of this body, Dart Everett, in 1990. And there was a specific dollar amount appropriated, and there was a plan put in place for the further funding of that reappraisal project. So we had a rather clear pattern established. We also had the language in our current charter which says that this body authorizes a reappraisal. It does not say what Mr. Fisher and other members of the select board, as well as the town manager, were telling us through communications in the Brattleboro Reformer in December of 2008, namely that this body approves the work product of the listers who already had initiated the reappraisal. And that was started actually in January of 2008. They had no authority to do so. They had no guidelines as to the amount of monies to be appropriated for that project. That's the first objection I have. Why should we give up that power that has historically been a part of this body? The language of the town charter has never changed, and only because of a misinterpretation and some faulty legal advice did we fall into this trap in the last decade. Secondly, if you take a look at the proposal of the commission, it grants all of that authority to commence a reappraisal to the select board and the town assessor, and leaves this body out of that decision-making process. However, there are no guidelines laid out for us to know what it is that causes the select board and town assessor to trigger a reappraisal. The second part of this proposal that I find objectionable is that it completely eliminates the administrative role of the listers, which I think is extremely dangerous. And the reason I say that is because this body, the town assessor, in reality needs a buffer zone around him such that there will not be undue influences exerted upon him as he makes his independent decisions on assessments. That undue influences can come from the town manager and or the select board. And so what I'm saying is one of the important roles that the listers can and should be performing for the town assessor is to give him a place to go if he feels he's being unduly pressured into taking certain actions that unwisely and improperly influences assessments. Now, as I drafted this proposal, which I believe now each of you has a copy of the motion to amend, I won't read it to you. I will go down through it paragraph by paragraph and just attempt to explain why it is the way I proposed it. You may note that some of the language in there sort of parallels the same discussion that we had under the role of the library board in selecting the head librarian. And you'll also note that there's a parallel in that the library board has certain statutory obligations and a statutory role to play, as does the Board of Listers. They've historically, for several years, have had an administrative role established by state statute. So, if I may, I would just like to go quickly down through the paragraphs. Basically, in the amendment, now keep in mind, by the way, that I've attempted to keep these paragraphs corresponding to the paragraphs of the Commission's proposal. In subsection A, what we're really attempting to do is to adopt some of the language on the selection of the town assessor being selected by the listers, the town manager, and the select board, acting in a cooperative and collaborative manner. It's my feeling that we need to have certain checks and balances and certain shared responsibilities, as our preamble to our charter urges us to do, and that we do not need to have so much emphasis on this chain of command and authority resting at the top between our select board and our town manager. We need that buffer zone so that the assessor can have greater independence in performing his professional work, his or her professional work. I'm also suggesting under B that what you see under the Commission's proposal, that be deleted. Under subsection C, actually it should be C1 and C2. I've omitted the sub 1. The first paragraph, which would be sub 1, it says nothing more than what the state law already says, but it's sort of a reminder to us that we have a partner in the preparation of the grand list, and that they can order us, the towns, when to reappraise. So we have to abide by their orders as it relates to the state educational grand list. The C sub 2, basically that's reverting back to the old system. It's unless ordered by the state, it's just simply saying, let's go back to the old 10-year rule. And the reason I am suggesting that in this amendment is so that we can avoid some of the problems that we've seen occur in this most recent reappraisal. Actually, when I first drafted it, I did have different language, and that different language did include all of the technical wording surrounding common level of assessment and COD. But I think that we're getting too complicated in using that kind of language, and it probably would be safer for us to revert back to the old system of reappraising every 10 years unless ordered by the state to do otherwise. One of the reasons I'm reacting that way is because I learned very recently that we have 2 vacancies coming up in this next March election on the Board of Listers, and there's only 1 candidate, and that 1 candidate has only been a lister for 1 year. The second, and he was appointed. He fortunately is offered himself as a candidate, but the second vacancy, there's no candidate running, which means that we're going to be right back where we started from in 2006 when we had a completely new Board of Listers. And what worries me there is, coupled with other factors, that new Board of Listers that we had in 2006 unfortunately got some bad advice from people with more experience that we should be running another reappraisal, and it turned out that that didn't work out too well for us because of the timing of it. The other thing is, my understanding is that our most recent reappraisal cost us $400,000 or someplace in that neighborhood. If you take a look at the past history of the cost of reappraisals, I think you'll find that the most we've ever spent in Brattleboro for a reappraisal was in 2005, and that was about $204,000. So what happened in the mistakes of this most recent reappraisal was we doubled up on the cost and we didn't get any better product. We only found 6 or 7% growth in the grand list. We just did a reappraisal that we really didn't need. Subsection D is basically to reaffirm what we already have, namely that the Board of Listers should continue with their administrative role. I think there's the one important role that they can serve for us is to provide that buffer between the Select Board and Town Manager in protecting the integrity of the grand list and providing the town assessor with an escape route if he's finding some pressure being put on him to take certain actions with respect to the grand list that he doesn't feel is supportable by the data that he has available to him. Another role that the Board of Listers administratively can assist us with is an educational role. They can undertake the responsibility for informing the public of a number of new types of reappraisal programs that are becoming into vogue in Vermont, and they've been utilized in other states for several years, but Vermont's a little slow in adopting these plans. And they could undertake the responsibility to educate the public as to these various types of reappraisals that are much less costly than the ones we've been undertaking for the last several years. Subsection E is actually not a change. It's part of the proposal, and I agree with it. I think the time has come where we cannot be mixing our employee staff with serving the dual role of an elective office, and I think there should be this ban. Subsection F is basically a response to the problem that arose in this most recent reappraisal, where we really overspent by a huge margin. When you spend double the amount on a reappraisal than you've ever spent in the past, then something must have gone wrong. And this is simply a way of shortening up the leash a bit and insisting that we go back to the old practice of setting a budget for reappraisal projects and giving us the opportunity to see an annual accounting of the funds that are being used, how they're being used, why they are being used in the way that they have been expended, and it gives us greater control over the monetary issues. The other point that this body should realize is that those state funds that come in annually at about the rate of $42,000 a year, they can be used for annual operating expenses. Now that's, I think, not a fact that's been made clear to the members of this body. But there, you know, rather than spending $400,000 on a reappraisal we didn't need, we could have been spending some of those monies in assisting us in reducing the annual tax assessing expense that we had to raise from local taxes. So I would urge the people in this body to adopt this measure. I think it's a responsible reaction to some of the problems we've seen in recent years.
Mr. Burrill has made a proposal of amendment to Article 30. Is there a second? Motion has been made and seconded. Any further discussion? Mr. Block just left. Yes, Ms. Sunday.
I have a question. On F, it says, it refers to the town administrators. I'm wondering who that is.
Mr. Burrill's interrogated.
I intentionally left that vague, if you wish to describe it as being vague. That's a matter I think that you folks should work out. I don't care who does the job. I'm just pointing in the direction of administrators doing their job. It
Well,
probably would be the finance director. I don't know for sure.
I would argue that the body, by the treasurer, that's roles are to keep the accounts of the monies as per the charter and per statute. So I wouldn't see why that would then become a responsibility, because if you see town administrator, one would normally make the assumption that would be the town manager. And so I think that needs to be clear. I think leaving it vague in the charter doesn't really make sense. And I'm just wondering why you would choose to make something vague when you list all the other people in every other
intent
section.
is simply to say, you figured that part out. Anyone who has a responsibility,
you?
You as the town manager can discuss that with the other players who have a responsibility to oversee funds. And if it means that the finance director is a player, the town treasurer is a player, then all of you get together and prepare and complete a report, the annual report, so that we, as the town meeting representatives, can understand what's going on with those funds. I don't really think we need to be specific as to who prepares a report. I just think that you have a general responsibility to do it, and you figure it out.
Question is on the amendment as proposed by Mr. Burrill. Mr. Dudman?
Unfortunately, I'm much slower of mind. I would like, as I listened to you, two things occurred to me. I, number one, never realized that there was an economic patent place of Brattleboro. But where all of this skullduggery is coming from that I'm hearing as the undertone is kind of surprising. But the second thing is that it sounds like you're setting up another separate arm of government which is independent of the rest of all of the structure of the town. And so I'm just at this place where I can't quite understand where you're coming from, other than somehow you've been dissatisfied with the past. And you want to go back to something maybe, I don't know, 1930s, 1940s.
Question is on the amendment, Mr. Coram.
Thank you, Mr. Moderator. I'm concerned, following up on the last point made, in proposed section A, where the listers, town manager, and select board would do the hiring of this town assessor. And I think Mr. Dubman's correct that that would be different than that is the select board and the town and the Public Works Department, for example, and the town manager don't hire the Public Works Director. That's something that the town manager does, and I don't think we want to get the select board in making decisions on hiring of the town assessor. Certainly, we have the obligation with respect to the town manager, but I don't think we want to get into essentially what would be a department head. So I have concerns about that initially.
Shall you amend Article 30 as recommended by Mr. Burrell? Mr. Phillips.
Thank you, Mr. Moderator. I have a friendly amendment to propose to address both Ms. Sondag's concerns and Mr. Corum's concerns. If that's in order, I'd like to delete in the second line the words "through the collective, cooperative, and collaborative efforts and decision of the town listers," and also delete the words "and select board," and just make it clear that the town manager hires the town assessor. And also in F, to make it clear that the treasurer shall prepare, as opposed to the vague statement that town administrators. I think that clarity is important, and I don't think it offends the important points of Mr. Burrell's amendment. I don't know whether he agrees. If he does, I'd love to speak to it.
Mr. Burrell? Why don't you use the mic, Leo, because we're trying to pick up the sound on the tape.
I don't have any serious objections to that. I'm just trying to throw ideas out here and to get people thinking about how we can improve on the situation that we've had, particularly in the last 4 years, where there have been some serious problems and serious mistakes made. So I'm not going to, I certainly have no objection to sub F changing that to the treasurer. The reason I threw the listers, town manager, and select board into a collective decision-making process is I think they all have a role that's important in dealing with the town assessor. And I would have thought that they wanted to participate in that role. You folks decide the issues. I don't feel strongly about it. I would just point out one thing to you, what I'm really getting at. In the town of Rutland, the city of Rutland, which is a mayoral form of government, the town assessor is elected by the people. And that's very important. Now, and the reason is because there's a recognition that when you get to the serious and sensitive subject of a town assessor, you can't have undue influences influencing him or her. And the way they dealt with it in Rutland is they made that an elected position. In conclusion, I would just simply say I have no objection to what Steve is asking.
Okay. Mr. Phillips.
Thank you. I just want to say that I don't take lightly the question of second-guessing a board that's worked so hard as this one has worked to come up with a proposal. But yet, Mr. Burrell has a passion for this, and I think he's fashioned a pretty darn good compromise, really, that does implement some but not all of the suggestions, and yet is true to the sort of the thing that Mr. Cummings and others mentioned about trying to retain authority of certain decisions with the town representatives. And so I'm going to support this, and one of the reasons I prefer it to what the Charter Commission has proposed is I find that some of the suggestions are vague in terms of the process for appeals. And this gentleman suggested that we want to go back to the way it was in the 40s. I think Mr. Burrell is proposing to keep it the way it is rather than to go back to some antiquated version. And I may be out of date on Vermont tax appeal process, but unless it's changed just recently a great deal, the first line of appeal is to the listers. And so the proposal doesn't make crystal clear what happens. I think the way I'd read it is the first grievance would go to the assessor, but it probably ought to say that. Then it says the Board of Listers in proposed section D shall act as a Board of Appeals. And what I don't know is where does that put the Board of Civil Authority? Or doesn't? Does the Board of Civil Authority still have the next level? It's not in there. And it probably should be if we want to make it clear that we're not throwing that out as well. So I think there's a little bit of lack of clarity, and I like the idea of being able to go to the listers, a group of 3 people, and say, you made a mistake. I don't have a shed. I don't have a deck, or there is no hot tub. And for them to say, oh, yes, and I think you're going to get more of a response when you have 3 elected listers as opposed to, and I don't know if this is the proposal, whether the assessor will be doing the grievances, but if that's the case, I don't think you're going to get that kind of response.
Mr. Elwell.
What we're talking about is a legal document here, and some of the wording of this, I'm not sure what a court would deal with, and I'm talking about the statements that the town assessor shall be hired through a collective, cooperative, and collaborative effort. I don't know what all that means in legalese. I'm responding to the amendment. If
Mr. Cummings has a point of order.
Cummings, District 1, I understood the amendment to remove those words. And therefore, I don't think that's in order at this point.
Okay.
Well, I don't think we ever actually took any action on that issue. Okay. You accepted it, Mr. Burrell? Okay.
Mr. Moderator, if I could continue, I've got some other comments.
Yes.
I'm a little disturbed about the rather sinister comments about rather furtive kinds of things happening within town government. And as I've said before, I like to think that Brattleboro has a fairly responsible and professional town government. And it worries me a little bit that these kind of comments have entered the conversation of this body. And I further have a concern, Mr. Moderator, about whether these major changes are germane and permitted under the actions that we're taking in terms of amendment to our town charter. They're very substantial in terms of what's been recommended by the commission. In fact, entirely opposite of what's been recommended by the commission. And maybe they're okay, but I have that question.
Okay. I think what we're going to do is take a 5-minute recess, and I'd like the town attorney, Mr. DeGray, Mr. Block, and Mr. Elwell, come up to the rostrum, please. The meeting will come to order. That's the only, yeah, and that's what we're going to try to avoid. Yes. I think our first order of business is going to be to establish that we still have a quorum. With the clerks do the count. Okay, all right. There's one there. There's two. Two. Yeah. Two there.
What is this, the Oscars?
There's one there. Okay. We have a quorum right on the money, 73. We'll now return to Article 30, and let's make it clear that the friendly amendment made by Mr. Phillips was accepted by Mr. Burrill. So the question is, shall the town approve Article 30, which establishes a Department of Assessment, said article being already amended once? And we're voting now on the Burrill amendment. Mr. DeGray.
Thank you, Mr. Moderator. I think if I ask for a show of hands of how many people understand what's been going on for the last half hour, there might not be too many hands up other than some of the attorneys in the room, and I know my hand would be up. Given the severity of this and the comprehension by this body, I'm going to ask you to defeat this motion, this amendment, and also defeat the proposed article change, and that the select board, under its powers under the charter, would work to and have to bring language forth in our March 12th annual meeting for an amendment that we would have more time for us to comprehend and understand. I do not believe that we are going to be doing an appraisal within the next year, so I think that given the severity of the technical knowledge here, it is in our best interest to defeat both the amendment and the article so that we can work together to get a better understanding and clarify some of the stuff that's here. And I only say that because there are several people that when I walked through and I said, do you understand what we're doing? And several people shook their head no. And so this is important. I don't dismiss with all the effort that Mr. Burrell has put into this, but the fact of the matter is we should truly understand the impact of what we're doing here today and make sure that we understand the implications of the vote that we cast, one way or another. So I urge you to defeat the amendment and also the original article. Thank you.
Yes, Mr. Wessel?
Similar to, I'm sorry, is there a mechanism that doesn't require us to defeat both of these? Isn't there a tabling we can do, or?
No.
There's nothing.
At the town meeting, we either have to vote an amendment or an article, any article, either up or down. You can't continue it unless you continue it to a designated meeting that's coming up. And there are a lot of problems with doing that as far as the Charter Committee is concerned in getting these recommendations up to the Vermont legislature. It would just delay that whole issue there. So this is the kind of the compromise to...
My concern is that his proposal doesn't really, we don't have an official way to see that process happen here in this body. You know what you see?
Well, I would assume anything that the selectmen devise would be sent to all the members in the package for the March meeting.
Okay.
Mr. Elwell.
Yes, on behalf of the commission, I concur with Mr. DeGray's opinion that we vote down both the amendment and the original recommendation of the commission. We're really dealing with a very complicated subject here and a very legally entangling subject. And if we don't do it right, we're really going to be in the soup. So our recommendation is that we delay any action on this and vote both of them down and bring back a measured and understandable proposal to everybody concerned.
Mr. Burrell.
I don't really have any strong feelings about proceeding as Mr. DeGray is suggesting, Mr. Elwell is suggesting. The problem I have is we don't have any real assurances that we have a majority here already that are willing to vote both of them down. Because if only one gets voted down and the other gets voted up, then we haven't accomplished what I'm willing to settle for. If we vote both down, then we've really preserved and protected the two objections that I have to the Commission's proposal, namely that this body retain its power to initiate reappraisals and that the Board of Listers retains its administrative powers. If we vote the Commission's proposal down, we accomplish that goal, which is my goal. The only other thing I want to point out to this body is I did ask for the opportunity to speak to the Commission, and I was promised that I would be notified when you were going to be discussing this Lister function issue. when 2 months went by and I never heard, I was told I would be advised of the date, the time, the place that the matter would be discussed. But that never happened. So when I inquired, I was told, "Oh, I forgot." So I don't have any objection. I would love to meet with the commission and discuss it with them. I just would feel very uncomfortable after having gone through the work that I put into this to find that we didn't vote both down.
Ms. Stark.
Billy Stark, District 1. Just a question, I'm not clear. If we vote both of these down, does it then not become part of the charter?
That's correct.
So it then leaves it all out of the charter, and then it's up to the select board? Or we then vote to redo the charter again and put it in? I'm not clear on how that works.
Mr. Fisher.
If both are voted, if the amendment's voted down and then the recurring article is voted down, then what would remain is what the is in the current charter right now. And that would remain the same until such time as there's, through one of the 4 avenues to amend the charter, and Mr. DeGray is talking the avenue through the select board making that recommended change, that would go through its process and then be voted upon in due course. Does that answer your question?
Ms. Boboulas?
Thank you, Mr. Moderator. I just want to suggest, because people are wondering how they're going to make sure that it happens, and there is something that this body could do, and that is that you can direct the select board to, create another charter commission and, have these things, worked on by the charter commission. So it's not, there's a lot of powers that this body has. You can direct the select board themselves. There's a lot of things that you can do as a body.
Question is, Mr. Sprite?
I can't claim to understand either one of these fully and the consequences thereof. I do appreciate Leo's passion for this subject and knowledge on it. I'd like to propose that this body vote his up, and then if we vote the whole thing down, that will kill both of them. But if we are going to be voting up or down in the end on one or the other, his, as amended by Steve Phillips, I think, if I understand it adequately, serves my concerns better. The last reappraisal I was opposed to, for exactly the reasons that have been brought up. I thought it was unnecessary, unduly expensive, and started in a manner that I didn't understand to be consistent with our process in starting appraisals. So I urge people to vote up on his, and then if the body chooses to go the route as proposed by Mr. DeGray, we can vote the whole thing down. And that would at least give a sentiment of the body as to which direction we would like them to head in terms of the final result. Thank you.
Question is, shall you approve the amendment of Mr. Burrill as amended? Be ready for that question. If so, all in favor kindly rise and remain standing until counted. Yeah, Ms. Dowd?
Do we have our attention? I'm sorry. 2 quick things, please. Does anyone know what the last appraisal cost? Just roughly.
I think Mr. Burrill has that figure.
Well, he said 400,000. Is that correct? I'm sorry?
Miss Sunday.
I don't know, and I'm not sure where he got that number. I would have to find out.
Okay. So a little bit of clarification on that. The other thing is that I sit on the Board of Civil Authority and have for a long time. So when Mr. Phillips says, where does the Board of Civil Authority fall into this? We haven't answered that question, correct? Under this proposal, under Mr. Burrell's proposal?
The Board of Civil Authority stays right where it is. That's all set up by statute.
So we're assuming that's...
You're that last level of appeal, unless it goes to the courts over you.
So we're all clear on that? We are, but Mr. Phillips was asking. Okay. And the last thing I guess I have to ask is the main reason I got up was, if I understand this properly, the only person that's going to ask for a reappraisal will be the state of Vermont, unless every 10 years this board asks for a reappraisal. Well, I'm asking to have that clarified, Leo, because then I have something I want to say to that, depending on what your answer is.
Mr. Burrell is interrogated.
The preparation of the grand list is a shared responsibility of both the state of Vermont and the towns. The state of Vermont gets into the picture because they generate revenues for the educational grand list through our grand list. We're still a player in that scheme of things. The state of Vermont does certain calculations on two statistical measures, such as the common level of appraisal and the coefficient of dispersion, which are the triggering devices for reappraisals. They have the power by state statute to order a town to reappraise that portion of the grand list that is characterized as the state educational grand list, which has the effect of forcing us to reappraise as a practical matter.
Right.
If we do not receive those orders, then all my proposal has done is say, let's revert back to our old practice, which existed prior to the amendment made in 2003, which was, unless otherwise ordered by the state, we will reappraise every 10 years.
Okay.
Sort of a perfunctory...
Right, so that's what I'd like to speak to. Sitting on the Board of Civil Authority, used to sitting up there on the Board of Selectmen 25 years ago, one of the things that we learned on the Board of Selectmen was when we only reappraise every 10 years, some of the shock value, when someone comes in and their assessment value is changed, is huge. And sometimes by not waiting every 10 years, whatever this body decides to do, all of a sudden we've done a better service to our taxpayers that they haven't gone in a 10-year cycle of what their valuations have changed. That's what I wanted to speak to. I don't know what that time frame is, and the reason I don't know that is because sometimes we have big changes of value and sometimes we don't. But to have this stated every 10 years concerns me, because when we sit on that board and people come in, you can imagine if you haven't had any idea, if you've been in the same house for a long time, you come in and talk to us and you have no basis of why your evaluation should be so different. And so I really take issue with the every 10 years. I don't know what the time frame should be, but I think we should be careful what that time frame is. Thanks for everybody for their time.
Mr. Gavi?
Is it my understanding that we would continue this item until the March representative town meeting? Or this would be after?
If these are voted down, one of the provision in the charter is for the select board to bring forward a charter change, and this article here would be one of those. This article here would be something that would be brought forth in the March 12th annual town meeting for adoption. So that would give us a whole year to work on.
A whole year, okay, I understand. My one point is that I would hope that the people who work on this includes all of the stakeholders. It should, I hope that Leo helps work on this and some representatives from the Board of Civil Authority and whoever else, so that when we finally do have to consider this again, we come in with a proposal that has already been well hashed out.
Point taken.
Ms. Baboulas?
I just want to say that I just want to comment on the issue of shock factor on assessments, because I think no matter how often you do them, there's going to be some sort of shock factor. But part of the shock factor to residents is how high their taxes are. And if the figure that Mr. Burrell is quoting is correct, to spend that more than every 10 years if it's unnecessary, what services are we cutting out? What capital expenses are we not paying for because we're doing assessments that may not be necessary?
Questions on the proposal of Mr. Burrell as amended by Mr. Phillips? Are you ready for that question? If so, all in favor, kindly rise and remain standing until counted. Those opposed, kindly rise and remain standing until counted. The nays have it. The amendment is defeated. Question now recurs. Shall you adopt Article 30? All in favor, kindly rise and remain standing until counted. All those opposed, kindly rise and remain standing until counted. You have defeated the article at this point. Article 31, Mr. DeGray.
Thank you, Mr. Moderator. Inside joke going on up here. I move that the town approve the technical changes made to Article 7.
Is there a second? Motion has been made and seconded that the town approve the technical changes made to Article 7. Mr. Block.
And those include simply the capitalizations, the word representative in front of town meeting. They do not in any way impact the establishment of the Department of Assessment like we've been discussing, but they still remain technical and are consistent with the rest of the charter. So if you look, you'll see all of those changes right in front of you. They're not in any way related to what we've just been discussing for the last hour.
Question is, shall you approve Article 31? All in favor, kindly rise and remain standing until counted. Those opposed, kindly rise and remain standing till counted. The ayes have it, and you've adopted Article 31. Article 32, Chair recognizes Ms. Baboulas.
Thank you, Mr. Moderator. I move that the town approve the technical changes made to Article 8.
Is there a second? Motion is made and seconded that you approve the technical changes made to Article 8. Are you ready, Mr. Block?
Once again, there is no substantial change here. With the advice of town attorney, we have made it clearer the fourth charter revision pathway when it goes through a periodic charter revision commission. That pathway is now spelled out to reflect current practices. Heretofore, it had to be a little bit interpreted from within subsection C of this article. So there is no change whatsoever to the detail or the pathway. It's just all spelled out there in D of Article 8.
Are you ready for that question? Mr. Coram.
Thank you, Mr. Moderator. In subsection C, in the fourth line, it references annual town meeting. Should that be annual representative town meeting or representative town meeting, or should it just be annual town meeting as it is now?
That should
Member-
be annual representative town meeting.
Question is, shall you adopt Article 32? Are you ready for that question? Ms. Wilson?
I just have a quick question about this. Catherine Wilson, District 2, which is in paragraph D, it says, any recommendations approved by the Charter Commission shall be voted upon at a special representative town meeting. But what about situations like we're facing now where a article may come back to us at regular annual representative town meeting?
This is subject to the periodic research that a Charter Revision Commission undertakes. That is a comprehensive study of the charter, and it would be expected that every 15 years there's going to be a lot of work done there. Not nearly enough time would be available at a regularly scheduled annual representative town meeting, and that a special representative town meeting, as we have found out, maybe more than one, is essential.
Great, thank you.
Question is, shall you adopt Article 32? Are you ready for that question? If so, all those in favor kindly rise, remain standing until counted. Those opposed kindly rise, remain standing until counted. You've adopted Article 32. Article 33, Chair recognizes Mr. Corum.
Thank you, Mr. Moderator. I move that the town approve the technical changes made to Article 9.
Motion has been made and seconded by Mr. Corum and seconded that the town approve the technical changes made to Article 9. Mr. Block.
There is one change here, though it's technical, that might be confusing to folks, and it is in the existing charter, Section 2, repeal of inconsistent provisions. At the advice of town council, we have removed that as a recommendation. I'll let Mr. Fisher explain why.
Mr. Fisher is interrogated.
Thank you, Mr. Moderator. That's just because those acts of 1927, it's essentially so old, that's a carryover of that former Section 2 of what was former Article 8, now Article 9. So we're just deleting it as this statute being an act of the legislature would have the full force and effect of law.
Question is, shall you approve Article 33? Are you ready for that question? Mr. Corum.
Thank you, Mr. Moderator. Question, in the penultimate line of Section 1, I assume that the town and town school district, those should be capitalized, the first letters, or is that intentional?
Mr. Block is interrogated.
Pardon? I didn't hear the question. I'm sorry.
Yeah, in the penultimate line of Section 1, there appears the word town and town school district. And
Capital
in the third,
letters, yeah.
they should be capitalized like in the third line? Okay.
Yes. And we just, Mr. Dubman just pointed out in the previous article that there was another missing representative for representative town meeting under special representative town meeting, and I understand from town council that those can be corrected forthwith.
Question is, shall you adopt Article 33? If so, all in favor kindly rise and remain standing until counted. Those opposed kindly rise and remain standing until counted. The ayes have it, and you've adopted Article 33. Article 34, to transact any other business that may become before the meeting.
Mr. Moderator?
Mr. DeGray.
I think that we need a motion to reconsider we made a change earlier, and Article 29, and the technical changes And what I want to address there is the town school board taking their office as the amended language that we approve for the select board. So I want to make sure that that gets adopted, and I'm not sure if it's a motion to reconsider or that is just inserted.
Well, unless there's objection,
I would make a motion to reconsider. Article 29. Well, for the school board, and I think that question. Article 6, yes, excuse me. Article 6 is where we talk about the school board. And I just want to make sure that the school board language for when the school board takes their seats, we did it with the select board, obviously, that you approved, and we just want to make it consistent. And so it's in Article 6 where we would have to adopt that language for the town school board to take their seats.
That was passed at the last meeting. Was that passed today? I'm confused here. Somebody's got to bring me up something.
This is with regard to the terms beginning on the first meeting after the adjournment of the annual representative town meeting. We did that for the select board terms to begin on the Monday following the final adjournment of the annual representative town meeting. But Mr. DeGray is moving to reconsider the Article 29, which are the technical changes to Article 6, dealing with school board powers, so that that would be a technical amendment to Article 6 of the charter.
Okay.
Does that make more sense?
That,
right, so that the terms of the school directors would begin on, I guess, the first Monday, same language, after the final adjournment of the annual representative town meeting.
Mr. DeGray wishes to amend the technical terms in Article 29, which was actually considered today. So we can reconsider that because it's in today's action. Is there any other things to be stated in connection with that technical change? All in favor, stand and signify by standing. All opposed? You've adopted the amendment to Article 29. Is there anything further? Mr. Dimes.
I wish to commend Mr. Coram for his astuteness. I didn't pick it up, and I think many of us also didn't pick up the gist of his objection to Article 9, question 19, about the binding initiative process. He suggested, and he's perfectly right if you think it over in your head, that the process described there, if started today, that is, if we were considering an article, a binding initiative today, would not get on the ballot for more than a year. I'm sure it's no one's intention in changing that article's percentage amount that we make the process so cumbersome. But as Mr. Coram pointed out, a year and 3 months is much too long for something that may be of concern to the people. So I move that we quickly reconsider and vote on the article with amendment as follows. The select board or school directors, upon receipt of such petition, shall place the article on the warning for the next town meeting to be acted upon by all voters of the town by Australian ballot, no later than the next townwide election.
Point of order?
But as we have it now, first it goes to representative town meeting. See, my point is made by Mr. Frick's objection. We did not notice that we have a three-step process. First the select board, then the representative town meeting before it gets to a plebiscite of the people. I'm sure that's not our intention. Article,
Well, our first question to decide, do you want to reconsider, what's the article number?
question number 19.
Question number 19, in order to make a proposal of amendment. You're going to talk on the issue of whether we're going to reconsider?
He factually misstated something. I wanted to correct that.
Okay, you may speak.
It's not correct that one has to wait a year. If you read the proposed language, you'll note that on binding initiatives, if the date of the next representative town or town school district meeting does not fall within 60 days, a special representative town meeting shall be called. The same provision exists regarding the special general town meeting that may have to be called if this body votes yes on the binding initiative brought forth by the voters. And this, as you call it, three-pronged approach is consistent with the existing pathway in our charter